Start. Hello and warm welcome. Today I will talk about a very important topic, that is law of contract. And today's topic is covered under our certificate program in cooperative law and business law, that is CCLBL, which is offered by School of Law. So today I will cover some of the aspects of law of contract. So in half an hour time, it is not possible to cover all the areas, all the. It is not possible to cover entire act, but some of the basic things I will try to cover in this presentation. So for first, we have to understand the definition of an agreement, because an agreement is a contract. An agreement enforceable by law is a contract. You will see later. So an agreement, it is very common term which everybody understands, everybody uses in day-to-day affairs. So every promise and every set of promises forming consideration of each other is an agreement. So, simple example we can give. Suppose one promises to sell his car, and another promises to buy the car. Then this is an agreement, because both are the consideration of each other, and both have promised to do something. One has promised to sell his car, and another one has promised to buy the car. So this is a very simple example of an agreement. And generally we use agreement and contract interchangeably, but there is a fine distinction between the two, and at times for practical purposes there seems to be no difference as such. So agreement is a promise or set of promises which two parties has agreed to fulfill against each other. So now in the next slide we see the definition of contract, and it is defined in the Indian Contract Act as an agreement enforceable by law. So an agreement enforceable by law, and it is a contract. So what are the agreements which are enforceable by law? There may be certain kinds of agreement which law does not consider it to be binding. Suppose an agreement to do some illegal things, an agreement to we can say agreement to indulge in human trade, or agreement to do business in prohibited goods, prohibited drugs, or to for sale and purchase of arms, etc., or to agreement related to gambling. So there are a number various kinds of agreement which uh, are illegal or immoral, or which in common parlance we say against the public policy. So these types of agreements are not enforceable by law. Law does not take cognizance of these kinds of agreement. So when we say contract, it, it, it signifies that an agreement which is enforceable by law. So there are certain conditions, there are certain requirements under the Contract Act which needs to be complied with to make an agreement binding or make an agreement contract to consider an agreement as contract. So before coming to that, there are certain other terms which needs to be understand. So another very important concept we can see in the next slide is related to uh, proposal, uh, lawful proposal. A proposal is an offer. In English law, we call it offer by one party, and the other party, if accepts that offer, then it both the parties enter into a kind of legal relationship. So when one person signifies to another person his willingness to do or uh, his willingness to do or uh, sorry his willingness to do something which he said to make uh, is called a proposal, and it should be lawful. Suppose one agrees to one offers to sell his car. We come to our previous example which I have given earlier. Suppose one proposes to sell his car, then it is a proposal. So it's a lawful, it's a legal proposal. Everybody has a right to sell or buy his his things. So it's a legal thing. It's a legal proposal. So it's a lawful proposal. So if a person wants to sell his car, then it is a proposal. So there are certain conditions for a proposal which we can see in the next slide. Firstly, the proposal must be specific and certain and should not be vague or empty. It should be specific. The person to whom the proposal is made should be in a position to understand the nature of the proposal. Suppose somebody says that he will sell uh, a few goods. So he has not specified how many items or what kind of goods he will sell to another person. Then it is not a specific proposal. It cannot be ascertained what the intention of the seller is. So the proposal should be certain. And another thing, it must be intended to create a legal relationship. Uh, Legal relationship, a relationship of a buyer or seller, or we can say to provide a service or to provide a personal service such as uh, painting, carpentry, or any kind of service based on the person, which we call service of personal nature, personal contract. So there should be a kind of certainty about the proposal, and it must be proposal should be such that it create a kind of legal relationship between the parties. And another point is it must be made in it must be made to another person with a view to obtain his assent. Proposal should be made to obtain the uh, acceptance or consent of the another person. Suppose one wants to sell his car, then he intends to make a proposal that if the proposal is accepted, he will sell his car on a consideration on a certain amount. Another point, it must be communicated. This is a very important point. Suppose one makes a proposal and he does not communicate to another person, then it is not a proposal. Proposal can be communicated to one person or set of people, or to a general public, to all. Suppose one wants to sell his car, then he can put an advertisement that he wants to sell his car. Whoever agrees to buy it, he has to pay a certain amount of and can take the car with him. So this is the proposal to the entire world. Anybody can accept the proposal and fulfill the conditions which is mentioned in the proposal. So proposal can be to a specific one person or to the entire world, and it must be communicated. It must be capable of being accepted. Uh, its proposal should be of such kind that it can be capable of being accepted. It must be absolute and unqualified. This is also an important consideration, that a proposal should be unqualified, be absolute. There should not be any condition, because if there is a condition, then it is a not a complete proposal, and the other person who accepts, who agrees to that condition, then it becomes another kind of proposal. There is a proposal should be absolute. Another point which is related to is now we can move on to our next slide, and that is must be it must be given to it must be given in a manner specify sorry, now we come to the another that is acceptance. And acceptance is it must be sorry, there is some white. Now when we talk about the acceptance, there are certain points which needs to be taken into consideration, that it must be given to in a manner specified in the proposal, or according to the usage which is prevalent in the business in question, it must be communicated to the proposal, and another important point is that it must be given in a reasonable time and before the proposal is withdrawn. So it should the acceptance should be given in a reasonable time. So when somebody makes a proposal, then another has to accept it. Then the relationship of promiser and promisee is created. The proposer is called the promiser, and the proposee, the person who accepts is the proposal is called the promisee. Uh, the important point here to be noted is that the proposal and acceptance may be expressed or implied. It may be in specific terms, or it may be implied by the conduct of the parties. Uh, so, a contract, it is not necessary that the contract should be entered into by a written. There should be a written document which specifies the terms of the contract. It is not necessary. Contract can be implied from the conduct of the parties. Suppose, for example, one person rides on a rickshaw and tell the driver to take him to a particular place. In this case, although there is no specific, there is no written contract as such, but there is a contract because one has two people have agreed to certain things. There is a proposal, there is a acceptance, and there is a consideration also to for this. So it is a valid contract. So now next point is related to the capacity of to contract. There are mainly three conditions. Firstly, the person who are entering into contract must be major, that is 18 years of age or above. A contract with a minor is a void contract under the Contract Act. There are certain situations where the minor's property can be made subject to the expenses which the other person has incurred, but generally it is the contract is between the two adults. Contract can be between legal persons also. For example, contract can be between the two companies or between a company and an individual. So company as a legal person. So it is the companies can also or a legal person can enter into a contract. Another point is the person who enters into contract must be of sound mind. He must be he should not be an insane or a person with unsound mind, because for a contract there should be a consent. There should be consent of the both the parties, and the consent should be free. Free consent means when the two people agree for the same thing in the same sense. So, for a valid contract, there should be a person should be of a person should be of sound mind. A person should not have been disqualified or barred by any law to enter into a contract. This is an important aspect. Suppose, for example, under insolvency laws, a person who is insolvent or bankrupt uh, has been, I mean, uh, cannot enter into a contract. So he is subjected to certain uh, restrictions. So there may be other situations also. So mainly the person should be of sound mind, and the person should be a major. And if the law permits, law disqualifies any person to enter into a contract, then that person can also not enter into a contract. So these are the people who are capable of entering into contract. Now, in the next slide, very important concept, that is consideration, lawful consideration. Consideration, in simple terms, we can say money or something which the other person promises to pay with for to another person for doing something. For example, in a if A sells his car to B, then B pays a certain amount to A. Then that amount is called consideration. So consideration in simple terms means something in return, a kind of you can benefit which the other person derives, or interest or profit, or any kind of valuable which the other person gives to which one person gives to another person. So consideration should be real. This is the law. And there are number of cases. Consideration should not be, it need not be adequate, but it should be real. It should be other person should a person of a reasonable person should a person of ordinary prudence should understand that it is a consideration. Suppose one uh, sells his car of one for 1 rupee, then it is not a it may not be a valid consideration, because consideration is not real. So when we go to the court of law for enforcement of a contract, the courts takes into account the fact, this fact, whether the consideration is real or it's just a formality kind of thing. The consideration consists of cash, immovable property, in something in exchange, etc. So these are the certain aspects which are related to consideration. Another point which I want to make here is that and the object of a contract should be lawful. It should not be against the public policy. Suppose a contract for gambling, contract for human trade. Uh, these are the these are not the lawful objects. Contract of a restraint of marriage, contract of restraint of trade. Uh, Section 23 to section 30 of the Contract Act talks about the various kinds of contract which are void contract, which are not permissible by law. Uh, so, the uh, points which we have covered in our today's presentation is what is contract. Contract is a agreement enforceable by law. An agreement is a set of promises, a mutual promises between the two parties, and the proposal and acceptance. The important thing with regard to proposal and acceptance is communication. Suppose one has put his acceptance in transmission. So suppose one has posted his acceptance, then it in the acceptance, then the contract is complete on his part. So proper communication is necessary. Communication, the offer and acceptance should be communicated in the manner specified in the, sorry, acceptance should be communicated in the manner specified in the proposal. And nowadays the contract can be entered on telephone, emails, etc. And email communications, electronic communications are also acceptable means of communication. So, the study of law of contract is very important for entering into an even for a cooperative society. The knowledge of contract is an important consideration. So, if one party does not, violates the contract. Suppose one person has agreed to sell his car to B, and he has sold his car, and B does not pay the consideration, or B has accepted the proposal for selling his car, for this proposal put forward by A, but thereafter A withdraws, withdraw his proposal. The acceptance has been communicated, and thereafter the proposer withdraws the proposal. Then what are the remedies available? Mainly the remedy under the Contract Act is the damages. The party who violates the contract is liable to pay the damages, and the other party can sue him for damages. Another remedy which is available under the Specific Performance Act is the remedy of specific performance. The court can direct the party to fulfill the contract, to abide by the contract, to complete the contract. So, these are the certain important things which I have tried to cover in today's presentation. Thank you very much.